Good afternoon, one and all. As a matter of policy, the government has declared the digitalization of everything, including the payment, and other transactions. So everybody is interested to do the things or to adopt the transactions electronically. Day in and day out, we come across the electronic record, digital evidence. If any transaction is done electronically or digitally, it is in fact easy to find out the person who did the transactions, who committed the crime. But we are in an era of this digitalization. At the same time, it is necessary to see that the people's privacy is protected. I believe that the privacy of the people is in danger. The government has framed the laws. The Information Technology Act has been brought. Thereafter, rules have been framed so as to protect the data, also to protect the privacy of the people. But the basic question is, are these rules sufficient to protect the privacy of the people? In my view, the rules framed under the IT Act are not sufficient or enough to protect the privacy of the people. Take for example, the Aadhaar scheme was initiated by the Government of India way back in the year 2009-10. The scheme was launched simply on the basis of one circular issued by the ministry. There was no provision that somebody, if had shared the private data, biometric data, or if such a data had been used for any other illegal means, then what is to be done? There are rules framed under the IT Act which provides that if somebody hacks the data or shares the data, such a person can be liable for to compensate the victim. But there is absence of rules to punish somebody if somebody shares the data, because the rules which have been framed under the IT Act, they do not provide any punishment. The provision is only to inflict the compensation to the victim, that too the extent of 25,000 rupees. Is it sufficient? And that too, that victim has to wander from pillar to post to get the justice, to get the compensation. We don't have expertise people. We don't have the good and the tech-savvy investigators up to the mark. We have very less people investigating the cyber crimes in police department. We have no expert judges in this field. We do not have experts, government leaders. We do not have experts, judges. We do not have the people who will try the cases. So very few of us are expert in this field. But every judge has to try the cyber crime case, cyber laws case. It does not mean that every judge is an expert. So things are required to be amended, the laws required to be amended, the rules are required to be redrafted. We need to have a revisit to the rules. The loopholes, insofar as the loopholes are concerned, see, n number of rules have been framed. The private policy has been framed by the Government of India. The rules have been framed the way back in the year 2011. But as I said earlier, if somebody commits the breach of those rules, what would be the effect of such breach of rules? Is there any punishment? Answer is no, that whosoever commits the breach of those rules cannot be sent in jail. He cannot be prosecuted. He can only be directed to pay the compensation. The compensation, who will award the compensation? The adjudicating officer. In all the states, a person who is IT secretary is designated as the adjudicating officer. And the sitting of the adjudicating officer is at the state level. Say, for example, in the state of Maharashtra, his office is at Mumbai. In the state of West Bengal, his office is at Calcutta. So the person who wants to have compensation, he will have to visit to the capital, state capital, in order to get the very meager amount of compensation. Why we cannot facilitate the victims to have justice at his doorstep? Why we cannot establish the courts at the district level so as to award the compensation to the victims? It is possible, but I find that there is no willingness on the part of the government to establish such courts. The loopholes are required to be corrected by redrafting the rules. It appears that the experts' opinion were not sought or were not taken while drafting the rules. These things are required to be amended. The rules are required to be amended. It is not so that the judiciary is absolutely helpless or not doing anything. The things are gradually changing. The Supreme Court has framed the policy under the E-committee, which provides the digitalization of everything. We have, in very few states, a digital courts. In the earlier session, somebody was talking about the digital court and digital and cyber force. So, as examples, we have certain states digital courts where you need not plead, you need not put up your case on papers. You can file your case electronically. You can supply the documents electronically. You can give the documents to the adverse party electronically, means by way of the CD or the pen drive or any other computer means. So things are changing. At the same time, we need to make the necessary budgetary provisions for training to the investigators, training to the all law enforcement agencies. So also, there is no procedure, as I believe, that every department should have their own manual. For example, the police department has their own manual. In Maharashtra, there is a Maharashtra police manual. In other states also, likewise in other states also, there is a police manual. The police are working as per the manual. There is, in no manual, there is a provision as to how to gather the electronic record. Very recently, the Income Tax Department has framed certain rules. They have made a compilation which is known as the manual. All these income tax authorities, they do their work, they seize the data and material in accordance with the manuals. But in other departments, there is no manual, so it is immensely necessary to have manuals for each and every department. For example, the courts are functioning because there is a court manual. But in the said court manual, there is no provision as to how to prove the electronic record, how to gather the electronic evidence. So every court adopts its own procedure to prove the electronic record. There is no uniformity in the court procedure while accepting the electronic record in the court. There needs to have SOP, standard operating procedure, for all over the country so as to make the electronic evidence admissible. Recently, in the year 2014, the Honorable Supreme Court laid down a law that if any electronic record is to be proved, say CD or pen drive or any computer output is to be proved in the court, it should have certificate issued under Section 65B of the Indian Evidence Act. Now let me know, see, if you go to petrol pump, you fill the petrol and you get the receipt bill. That bill is electronically generated. If something happens in future, if I wish to file a case in the court of law, what the law demands that there should be a certificate. Can you expect that the petrol vendor would be issuing the certificate to each and every person who is filing the petrol? This is something illogical. So, in view of this law laid down by the Honorable Supreme Court, the fate of the cases has been now decided, or going to be decided in the form of acquittal. So, it was expected from the government to have revisit to the provisions of the Indian Evidence Act and to lay down or to provide certain safeguards to make the electronic evidence admissible by promulgating the ordinance or by amending the act. But it has not been done so. So time has come for the government to think over this, to ponder it, and to get the experts' opinion. See, this is not the subject of only expert persons. The BE people, the technocrats, they talk about only the cyber security. They talk only about the technology. But there has to be combination of technology with the legal field. So there should be combination of techno-legal people to frame the rules under the IT Act to make the electronic evidence admissible. If this is done, then we will have good future, we will have good cases to prove before the court.